Thank you, Lewis. Rob Gasaway of Kirkland and Ellis. It's a pleasure to be here. I'll start out with a brief disagreement with my friend Lewis. I also practice in Washington, D.C., but my parents live in Springfield, Illinois. My brother is a Hoosier from Indiana. He's the world's expert on Big Ten basketball. So it's me, not Lewis, who is the true voice of the heartland on this panel. I agree with much of what has been said. There's a couple things I don't agree with, but I think what we can all agree on is that precedents play a much lesser role in preemption cases than elsewhere. If you would have looked at the literature maybe 10 or 15 years ago, you would have seen this remarkable anomaly. The constitutional doctrine that's applied most often by the Supreme Court is preemption, but there was never any independent preemption jurisprudence or preemption discussion as such. It's not like the Equal Protection Clause of the First Amendment where you could really get articles on that. That is changing now as there's more focus on preemption as a doctrine as such. I still think it's in its infancy, but I think especially for this audience where many of us are practitioners, either as attorneys or as judges, the real question comes down to not case law, not common law, not the reach of precedent, but differences in practical judicial approaches, and that's what I'll focus on. So we'll start out with just a brief background, then a description of judicial approaches. I think what's remarkable here is judicial approaches are not dependent on the actual judge judging. And what I'll do is take some specific examples, the GEIER majority versus the GEIER dissent, and then I'll look at what I think is probably the most excellent preemption decision in the recent past, U.S. Chamber of Commerce versus Brown. And what we'll do is we'll look at the judicial approaches in that, and then we'll make some tentative suggestions what we'll see looking ahead. Okay, I agree. There's a preemption pendulum. It's like offense and defense in football or pitching and hitting in baseball. It swings back and forth. I don't think that you can say that preemption is dead. I do think that Lewis and his colleagues in the plaintiff's bar had an excellent Supreme Court term. GEIER remains a landmark. I think GEIER was the first decision of the Supreme Court that was really noticed for the quality of its reasoning. It remains good law. The dissent in GEIER focused heavily on this idea that a couple of people have alluded to, that we should really outsource constitutional law. We should outsource preemption to agencies. Agencies should open up their rulemakings. They should invite in the states. They should say, how far should we go in preempting state law? That was rejected, not only in Wyeth, as people have talked about, but in other recent cases, in Riegel. Again, I won't go into the details, but what's remarkable is how little deference Justice Scalia, the most inclined to defer justice on the Supreme Court, gave to the Solicitor General's opinion. Similarly, in the Cuomo case that came later in the term, remarkable lack of deference to the agencies. I think what the court is saying is preemption law is constitutional law. That's for us to decide. The dissent's footnote 22, on the other hand, in GEIER has proved prescient. That was the first footnote in the Supreme Court opinion, or first discussion of the Supreme Court opinion that I'm aware of that sought to connect preemption jurisprudence to broader trends in constitutional law. And this discussion by Justice Thomas in Wyeth, this question over the status of implied preemption, really has a deeper root. The question is, how does preemption fit in with larger principles of constitutional law? But my fundamental thesis here today is the GEIER approach. The approach of the GEIER majority is fundamentally sound and was in fact extended very recently in the Chamber of Commerce versus Brown case. So what do we talk about? The GEIER rules, simple rules for bad decisions, the GEIER majority, key signposts to good decisions, and in search of excellence, Chamber of Commerce for Brown. How did the GEIER dissent go awry? It misapplied the presumption canon. It misapplied the touchstone canon. That's the truism that the touchstone of every preemption case is the intent of Congress. And it overlooked, or was not as sensitive as it should have been, to the contours of the specific federal law and its practical interactions with state law. The presumption canon in the GEIER dissent said two things. And this, if you take away one thing from this presentation, this is really the key slide. This argument in GEIER. The presumption canon's purported virtues, according to the GEIER dissent, placement of the preemption power, quote, in the hands of Congress, requires Congress to speak clearly. So we're going to put the burden on Congress to speak clearly about preemption, just the way we do about waivers of sovereign immunity and the like. But, huge but, first of all, let's start with the text of the Supremacy Clause. The text of the Supremacy Clause says right after that federal law shall be, quote, the supreme law of the land, it says, and the judges in every state shall be bound thereby. So if you're looking at the Supremacy Clause, it's peculiarly directed to judges and peculiarly directed to state judges. Second, the legislative history of that provision, and we won't go into it, there's a discussion of this in the academic literature. James Madison thought that Congress should essentially have the preemption power. He proposed what a lot of people call the Madisonian veto or the Madisonian negative. He said Congress should basically review state laws for compliance with federal law. That was rejected in the Constitutional Convention. The Supremacy Clause emerged instead. And what also emerged was not this potent power in Congress, but the divided power of Congress between, as we all know, the House, the Senate, and the presidential veto. That creates an incredible status quo bias in our system of government. As we all know, it's hard to get legislation passed. If you don't believe me, ask President Obama how hard it is to get his legislative agenda enacted, even with large majorities. And so what does that mean? That means as a structural matter, it's just not possible for Congress to anticipate future events when it passes a major regulatory statute, be it the auto statute in the 60s or the medical device statute in the 70s. It cannot envision what events are going to happen or technologies are going to emerge 30 or 40 years later. It's not possible for it to anticipate how the states will try to get around those statutes, as they surely will. And it's not possible, and this is the most important point, it's not possible for Congress ever to respond as events emerge. Because, again, Congress was designed specifically to require time, deliberations, and supermajorities in order to pass legislation. Again, look at the current situation in Washington. So the response to the presumption canon in GEIER was that there's no special burden to finding implied preemption. And that, interestingly, was that finding and that ruling was made even in the context when there was express savings provision for common law liability. This touchstone canon in the GEIER dissent emphasizes that non-statements and non-actions, if Congress or the agency had intended to preempt, surely they would have said something. Again, the GEIER majority, you must distinguish express from implied preemptive intent. And in cases of implied preemptive intent, there's no specific formal preemptive statement that's required. This was said more pithily by Justice Scalia in the Riegel case that we're discussing today, writing on behalf of a 7-person majority. Justice Scalia said the operation of law enacted by Congress need not be seconded by a committee report on pain of judicial nullification. So yes, this is a matter of congressional intent, but when we're talking about implied preemption, we're talking about implied intent, not express intent. And then finally, the critical and determinative factor, and we'll see this later in Chamber of Commerce v. Brown, in all preemption cases, are the contours of the federal law and its interactions with state law. That's apparent on the face of those laws. You don't have to go to legislative or regulatory history for it. Some of the key questions, is the federal law an optimum or a ceiling and a floor, as Allison put it? Does the federal law seek affirmatively to establish private choice in a law-free zone? What if the rule applies to all plaintiffs? What if the rule applies to all states? And again, the GEIER majority looked at what the agency intentions were. It said it deliberately sought a mix of several different safety systems. It did so by setting up performance standards and allowing manufacturers to, again, affirmative decision in favor of the negative, affirmative decision in favor of a law-free zone. You don't have to look at legislative history or administrative history, but just look at the law itself and see its 4-year phase-ins, see its percentages rising from 10, 25 to 40 to 100, and you conclude that it specifically wanted to have manufacturer choice. Okay, an excellent decision, Chamber of Commerce v. Brown. Question presented is California's purported limit on the use of state funds for advocacy in favor of unionization impliedly preempted by the NLRA, the National Labor Relations Act, the key federal labor law, as a de facto regulation of union organizing activity? Answer, yes. NLRA includes no express preemption provision, date of decision June 19th, 2008, after Riegel, but before Wyeth. Signposts on the road to Brown. What were the key elements of the judicial approach? What I call the Rodriguez canon, what I call the U.S. term limits canon, and close analysis of enforcement and remedies like the court engages in other areas of the law. Critically, these canons are drawn from non-preemption cases. These are general canons of interpretation of the law generally or constitutional law. The Rodriguez canon, it frustrates rather than effectuates legislative intent simplistically to assume whatever furthers the statute's primary objective must be the law. There's always competing objectives. Again, we see this in Justice Scalia's opinion in Riegel. There's safety, but then there's also effectiveness. There's holding bad products off the market, but there's letting good products onto the market. You've got to look at both sides of the equation and not only say, well, this is a safety statute. It must be concerned and only concerned with safety. The U.S. term limits canon. Constitution nullifies sophisticated as well as simple-minded ways of evading the Constitution. You have to ask whether the state law is an indirect attempt to accomplish what could not be accomplished directly. So there's always an equivalence question here that a court in a preemption case could ask. Is the state law really trying to do by indirection something that is prevented from doing directly? And then finally, sensitivity to enforcement methods and remedies. Federal takings law, obviously a very complex body of law, but one of the key themes in that is the difference between a compensatory remedy and an injunctive remedy. And again, very close sensitivity to that key distinction in Chamber of Commerce v. Brown. So let's look at that decision, look at the judicial method that's applied in that decision, what we can learn from it. Decided June 19th, 2008, again very recently, a 7-2 decision finding implied preemption. The dissent rested on a narrow factual ground. The main points about implied preemption and preemption method were not disputed, but just on a narrow factual ground, only two justices dissented. Again, an excellent example of proper preemption analysis and judicial approach. What are those elements? Interestingly, no discussion of the presumption against preemption, even though this was an implied preemption case. No discussion of the touchstone canon. Those were thought to be truisms or implied. Recognition of an affirmative sphere of perfected private activity for the benefit of both the union and management. Express consideration of how the statute would operate across future cases if it enabled all parties to take advantage of the statute. Express consideration of the 50-state quilt that would be created. Close consideration of the form of the rule. Is it a regulatory rule or a non-regulatory spending rule? A Rodriguez-like discussion of competing objectives. A U.S. term limits express recognition that states cannot do indirectly what they can't do directly, and close examination of the practical workings of state law enforcement and the interactions with federal law. The decisive point really came down to the question of the majority requiring a safe harbor if the state of California wanted to regulate in this manner, and the dissent saying, no, you don't need a safe harbor, you have to look at the enforcement mechanism as it is. These 9 or 10 bullet points I would commend to you as the appropriate methodology followed in Brown and that should be followed in each and every implied preemption case. Now, is this just idiosyncratic between the justices? And the final point I want to leave with you is that, interestingly, the author of Brown, who employed a method so at odds with the dissent in GEIER, was none other than the author of the dissent in GEIER, Justice Stevens. My favorite preemption case was, in fact, written by Justice Stevens very recently, and it gave a strong endorsement to implied preemption. Now, what does that tell us looking forward? I think it tells us that the pendulum swings back. I think, again, with Lewis, that the plaintiff's bar had a very good term, but I do think the pendulum is going to swing back. I think that purposes and objectives preemption or implied preemption, whatever you want to call it, will continue because it has to continue. There's just too many contexts in federal law where there is no express preemption provision, like the federal labor laws, and you're going to have some doctrine of implied preemption. Whether that will rely on the Hines versus Davidovitz precedent, will it be called purposes and objectives preemption, I don't know, but it will survive in some form. And I do also agree that as the business community looks forward, they need to step up their appellate advocacy. I think for a long time, there was an assumption that the Solicitor General could win preemption cases. Justice Greier never voted against a Solicitor General recommendation of preemption for the first decade he was on the Supreme Court, except in ERISA cases where the administrative element is minor. I think a lot of business lawyers said preemption cases are won and lost in the Solicitor General's conference room, not in the Supreme Court, and I do think there was a little bit of an awakening in this past term. Thank you very much.
Thank you.